Hello and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to Lecture 1 of Stage 1 of Conquer Prelims 2025. This year, Conquer Prelims initiative shall be conducted in 5 stages. In Stage 1, we will focus on current affairs of the period January to May 2024. In the second stage, we shall focus on high-yielding topics from the static portion of your prelims syllabus. In stage 3, we will focus on last 10 years question papers, PYQs of the last 10 years. In stage 4, we will focus on current affairs of the period June to April 2025. And in the last stage, we will have one-shot marathon sessions which will complete your syllabus of Prelims 2025. And for polity specifically, I will tell you now, in one session, one marathon session, in one shot, I will cover the bare act of the Constitution, which is going to be, I think, extremely fruitful for your prelims examination. And remember, this Conquer Prelims program is a paid initiative. And all you have to do is subscribe to our channel. That's how you will be paying us. So like this video, subscribe to our channel, and let's get started with Lecture 1, where we will focus on current affairs related to Indian polity from January to May 2024. And tomorrow we will have another class of Indian polity. So today, in total, 15 topics we shall be discussing. We will discuss lots and lots of MCQs as well. And towards the end, in our final 10 minutes, I will be taking your doubts, but only those doubts relevant for the examination. Is that clear? Great. Let's get started and let's look at topic number 1, Anti-defection law and Himachal Pradesh case. 52nd Constitutional Amendment Act. The year was 1985. 10th schedule got added to the Constitution. Because the Constitution says these are the grounds on the basis of which a legislator shall be disqualified. What are these grounds? Office of profit, change in the nature of citizenship, if you are adjudged insolvent, mental unsoundness. But Constitution further says that additional grounds of disqualification can be prescribed by Parliament by enacting a law. And in 1985, 10th schedule got added, which means now a legislator can be disqualified on the grounds of defection. What are the provisions of anti-defection law? 4 important provisions. Let's revise them very briefly. 1, if you voluntarily resign from your political party, you will be disqualified. If you vote against the whip issued by the political party, and this whip is a 3-line whip. So 1-line whip, 2-line whip, these are not coercive in nature. If you violate the 3-line whip, you are liable to be disqualified under anti-defection law. But here also, if the political party, remember this carefully, if the political party condones your violation, which means even if you have violated the whip, but the political party has condoned it, accepted it within 15 days, then you will not be disqualified. But if the political party does not condone your violation of the whip within 15 days, then you are liable to be disqualified. Third, if an independent member of the House joins a political party after the election, disqualified. If a nominated member joins a political party 6 months after the nomination, then you are disqualified. Which means a nominated member is given 6 months to join a political party after the nomination. But if you join a political party 6 months later, then you are liable to be disqualified under anti-defection law. Why is this in the news? Because in Himachal Pradesh, 6 MLAs, they had voted against their whip, or they had voted against their party candidate when it comes to the Rajya Sabha elections. To repeat myself, 6 MLAs belonging to the Congress party, they were disqualified by the speaker under anti-defection law. Why? Because they had voted against the Congress nominee Abhishek Manu Singhvi in the Rajya Sabha elections. But listen to me carefully. They were not disqualified because of this, but they were disqualified because they abstained from voting when it comes to budget. Sir, what are you trying to say? Although they had voted against the Congress nominee in the Rajya Sabha elections, but that was not the reason why they were disqualified under anti-defection law, because whip in the Rajya Sabha elections is not binding. Whip cannot be issued in a Rajya Sabha election, and I'll tell you why. But they were disqualified because they abstained from voting on the budget, because a whip, when it is issued to vote in a particular manner during a budget, it is binding on the candidate. It is binding on that member. And since these MLAs had voted against the party nominee in the Rajya Sabha elections, for that reason they were not disqualified, but they were disqualified because they voted against the budget or they abstained from the voting. But here, listen to me carefully. Another important thing. If the question is asked in the examination, could the speaker have disqualified a legislator for voting against the party nominee in the Rajya Sabha elections? For that reason, no. But it could be assumed that because you have voted against your party nominee, you have voluntarily given up the membership of your political party, which means you have voluntarily resigned. Because the courts have said, one of the provision of the anti-defection law is, if you voluntarily resign from your party, you can be disqualified. But voluntary resignation does not mean that you have to submit a formal resignation letter. That would be construed as resignation, voluntarily giving up the membership. No. If your conduct outside the house is such that we can assume that you have voluntarily given up the membership of your political party, even then you can be disqualified. But in this case, Abhishek Manu Singhvi of the Congress party, who was the candidate, he lost the election. Why? And that is how he later approached the court as well. And that is why this topic becomes important. The role of the returning officer. What is the role of the returning officer? For example, in Lok Sabha elections or in Legislative Assembly elections, if there is a tie, if there is what we call equality of votes, then what is the power available with the returning officer? He will, through draw of lots, pick one name, and it will be assumed that returning officer has casted his vote in favor of this candidate. That means this candidate has received an additional vote. Since there was equality, now you have received an additional vote, which means you are the winner. And this is something which is prescribed, mentioned under Section 65 of the Representation of the People Act 1951. But in case of Rajya Sabha elections from Himachal Pradesh, where Abhishek Manu Singhvi was the candidate and there was another candidate, there was a tie, equality of votes. But here the returning officer relied on Rule 81 Clause 3 of the Election Conduct Rules, under which if the returning officer, through a draw of lots, takes out a name, it is assumed that this name has lost the election. The other person, extra vote has been cast in favor of that candidate whose name did not appear in the draw of lots. That is how Abhishek Manu Singhvi approached the court and said, the High Court, and said the returning officer should have followed Representation of the People Act, which is the law, and not the Election Conduct Rules of 1961. And to summarize this, in case of Rajya Sabha elections, through draw of lots, whatever name comes out, it is assumed that this person has lost the election. And in Lok Sabha elections, Legislative Assembly elections, through draw of lots, when the returning officer picks a name, it is assumed that this candidate has received an extra vote, which means now this candidate is the winner. Let's look at some of the important facts. Voting in the Rajya Sabha elections takes place 2006 in Kuldeep Nayyar versus Union of India. Supreme Court said, if secrecy becomes the source of corruption, then transparency has the capacity to remove it. So there used to be secrecy before, and now through transparency, open ballot is used in the Rajya Sabha elections. But in this very case, the court has also said that if an elected MLA of a political party has voted against the party candidate, at best, you can attract disciplinary action from your political party, but you cannot attract the provisions of anti-defection law. So just because you have voted against your party candidate, that does not mean you will come under anti-defection law and you will be disqualified. Maximum disciplinary action can be taken against you. But through this, it can also be assumed that you have voluntarily given up the membership of your political party, and as such, you can be disqualified. Because that's what Supreme Court had said, that voluntarily giving up membership under the 10th schedule is not synonymous with only formally resigning from your party. Even if you have not submitted your resignation letter, we can assume through your conduct outside the house that you have given up the membership of your political party. How? Let's look at the case. Let's look at the question, and you tell me in the comment section what is the right answer. The whip is not binding in case of Rajya Sabha elections. Why? Because A, the voting takes place through an open ballot. The anti-defection law clearly mentions that whip is not binding in case of Rajya Sabha elections. The voting to elect MPs to the Rajya Sabha is not treated as a proceeding within the Legislative Assembly. The elections to Rajya Sabha is based on proportional representation system. You tell me what is the right answer. Yes, voting takes place through open ballot, but anti-defection law does not explicitly mention that whip is not binding in case of Rajya Sabha elections. But when we look at whip is binding in case of proceeding inside a house. Proceeding can be if a bill is to be taken up for voting, if no confidence motion or a confidence motion is to be voted upon, if a money bill is to be voted upon, that is considered to be the proceeding of the house. But voting for the Rajya Sabha elections is not considered to be the proceeding of the House. When it is not considered to be proceeding of the House, which means the whip is not binding, so C is the right answer. Clear? Let's look at topic number 2. Nabam Rebia case is related to another question on your screen. Let me know what is the right answer. Nabam Rebia case is related to A, the powers of the governor of a state, the powers of the Speaker of the Legislative Assembly acting under the 10th schedule of the Constitution, C, the constitutional validity of the 9th schedule of the Constitution, D, split in a recognized political party. What is the right answer? The powers of the Speaker of a Legislative Assembly acting under the 10th schedule of the Constitution. Why this was in the news? Because this Nabam Rebia case has now been referred to a 7-judge bench of the Supreme Court. Why? Because you are all aware, hopefully, that there was a split in the Shiv Sena political party. Matter went to the court. But then this question of Nabam Rebia judgment became very important. Because in Nabam Rebia case in 2016, what the Supreme Court had said, if a motion is pending against the removal of the Speaker, then the Speaker cannot decide on the disqualification petitions under anti-defection law. Which means who has the power under anti-defection law to disqualify a legislator? The Speaker. But if a motion is pending inside the legislature calling for my removal of the Speaker, I cannot act on the disqualification petitions. This was ruled by the Supreme Court in Nabam Rebia case in 2016. But the argument also was, if I am a defector, I want to defect, I want to join another political party, but I don't want Speaker to act against me. What I can do, I can preempt that Speaker will disqualify me if I have violated anti-defection law. But some of us who have violated anti-defection law, we will introduce a motion to remove the Speaker. Now, Speaker cannot act against us because we have preempted. We want to defect, But now we don't want the speaker to act against us. We introduce a motion calling for the removal of the speaker, and Nabam Rebia case, Supreme Court has said now speaker cannot act on these disqualification petitions unless and until that motion calling for the removal of the speaker has been dismissed, not passed in the legislature. Now, whether this is the correct position of the law or not, that is why this Nabam Rebia judgment has now been referred to a 7-judge bench of the Supreme Court. That completes our topic number 2. Topic number 3, Article 142 of the Constitution. Under Article 142 of the Constitution, the Supreme Court has the power, number 1, to issue such order as is necessary for doing complete justice. 2, to make any order for the purpose of securing the attendance of any person, discovery or production of any document, or investigation or punishment of any contempt of itself. Which of the above statement is or are correct? Only 1, only 2, both, none. That's why this question, C is the right answer. Because this is Article 142, Clause 2. And that is why this question has been picked up, because in every civil services aspirant would know that Article 142 deals with the power of the Supreme Court, that you can issue any order so as to give complete justice. But that's only half of Article 142. The second clause is that using Article 142, the Supreme Court can issue an order and you can bring somebody to attend the Supreme Court. You can ask for a document to be recovered. And if the investigation or punishment is to be given for contempt of court, whatever order is required to investigate that contempt of court case or to punish in that contempt of court case, order can be issued by the Supreme Court under Article 142. So both these statements are correct. Why Article 142 was in the news? Sometimes questions can also be asked. For example, once a statement was given in the prelims exam that Office of Profit Act has been amended 5 times. So sometimes these facts can also be asked. How many times has the Supreme Court explicitly used its power under Article 142 in 791 cases, according to a study conducted by IIM Ahmedabad? And this study focused on the period 1950 to 2023. In this period, in 73 years, for 791 times has the Supreme Court invoked Article 142. So if the statement is given in the examination that Supreme Court has rarely used Article 142 or Supreme Court has used Article 142 in less than 100 cases, you should know that number is quite large, 791. And why this becomes important for your exam? Because this Article 142 has been used, invoked by the Supreme Court number of times in the past 2 years. In fact, 3 years. Recently, a Dalit boy, his admission was denied because he missed the deadline to submit the fee. And the Supreme Court invoked Article 142, and that's how he got the admission in IIT Dhanbad. In Chandigarh mayor elections, where there was discrepancy, the returning officer had done something illegal. The Supreme Court quashed that proceedings and ultimately basically ruled that a candidate belonging to Aam Aadmi Party is the mayor of Chandigarh, invoking Article 142. But most importantly, it was in Delhi Metro Rail Corporation case. In Delhi Metro Rail Corporation, it was a very long case where the other party was Anil Ambani's company. It was ordered that this Delhi Metro Rail Corporation has to pay 7,000 crores to Anil Ambani's company because something went amiss. We don't have to go into the nitty-gritty of that case. But long story short, in fact, the review petition was also dismissed. And in the curative petition, and why this becomes important, because for the first time, the Supreme Court in a curative petition went into the merits of a commercial dispute and there invoked Article 142. We will not get too deep into that case because that may be relevant for the mains exam. Here, just keep in mind that in Delhi Metro Rail Corporation versus Anil Ambani's company, the court had asked Delhi Metro to pay 7,000 plus crores to Anil Ambani's company. But this was quashed in a curative petition by the Supreme Court invoking Article 142. And the most infamous use of Article 142 was in 2017 when the Supreme Court asked that liquor should be banned within the 500-meter radius of the national highways. So this is related to Article 142, becomes very important. Let's take a look at another question. Which of the following statements is or are true regarding Article 142 of the Constitution? Number one, it was adopted by the Constituent Assembly without any debate. The orders under Article 142 have to be consistent with the fundamental rights guaranteed by the Constitution, but can be inconsistent with the provisions of the ordinary laws. Article 142 cannot be invoked by the Supreme Court while deciding a curative petition. High courts have been granted similar powers by the Constitution. Select the correct code from below. 1 statement, 2 statements, 3 statements, all the 4 statements. Tell me what is the right answer. Article 142 was adopted by the Constituent Assembly without any debate. This is correct. Although it was to be taken up for debate, but then the Constituent Assembly realized that this plenary power should be given to the court and let them decide how to use it. The orders under Article 142 have to be consistent with fundamental rights, but can be inconsistent with the provisions of the ordinary laws. Incorrect. Why? Because the Supreme Court has said in Prem Chand Garg case, way back in 1962, that when the Supreme Court will invoke Article 142, it has to comply with the principles of natural justice. It has to not violate the fundamental rights guaranteed by the Constitution, and it can also not be inconsistent with the ordinary statutes, with the laws passed by the Parliament. It is only when the law is absent in a given situation, when the law is insufficient in a given situation, that's when Article 142 can be invoked by the court, where there is no other remedy available. Article 142 cannot be invoked by the Supreme Court while deciding a curative petition, and that's something that I told you about the Delhi Metro Rail Corporation case, where during curative petition, Article 142 was invoked. High courts have been granted similar powers by the Constitution. No, this power is exclusively available to the Supreme Court, and that is why one statement is the right answer. Clear? Lovely. Now let's look at curative petitions. You lost a case in the Supreme Court, then what you can do is you can file a review petition. Once review petition is dismissed, you can file another review petition, and that is known as the curative petition. But review petition can be filed when? Within 30 days of the judgment, and it is accepted only on 2 grounds. What are these grounds? If an error has been pointed out, when the judgment was given, an error has been pointed out, so we will ask the Supreme Court to correct that error. B, if new facts have been discovered. New facts have been discovered which can prove that I am innocent, which can prove I am not at fault. If new facts have been discovered, then review petition is accepted. And this review petition is heard by the same judge or by those judges who dismissed your petition previously. But even after the dismissal of the review petition, you can file a curative petition. But in how many days, in how many months? That's something which is not mentioned in the rules. Curative petition can be filed after the dismissal of the review petition, in a reasonable time frame can be important for your exam, because review petition can be filed within 30 days of the judgment of the Supreme Court. But then you can file a curative petition. In how many days? That's not mentioned. What is mentioned is in reasonable time period, you can file a curative petition after the review petition has been dismissed. And this is something which has been innovated by the Supreme Court. When in Rupa Ashok Hurra versus Ashok Hurra 2002, we don't have to get into details of what this case is all about, but maybe just keep in mind that it was basically a matrimonial dispute. And in that matrimonial dispute, the Supreme Court said, although finality of justice is important, but it cannot be at the cost of the justice. Yes, at one time, the judgment has to come to a final conclusion, but it cannot be at the cost of the justice. So after the dismissal of the review petition, within the reasonable time period, you can file a curative petition. But the grounds of accepting this curative petition is very, very narrow. What are the grounds? You have to convince the court that principles of natural justice have been violated when the review petition was dismissed. For example, the review petition was dismissed ex parte without hearing you, or your judgment was given ex parte without hearing you, or the judge who gave this judgment was biased against you. You have to then tell the court that there was a conflict of interest because that judge had a conflict of interest in this case. Or you have to convince the court that the process of the court was abused, whatever that process is. And those judges who dismissed your review petition, listen to me carefully, those judges who dismissed your review petition and the 3 senior judges of the Supreme Court together will hear your curative petition. And if the majority of them decided that yes, this case needs to be heard because principles of natural justice have been violated, because the process of the court has been abused, because the conflict of interest has now come to light, it will accept your curative petition, but the chances of winning in a curative petition is less than 1%. That means more than close to 99% of the curative petitions are dismissed, not accepted, because the grounds on the basis of which these petitions are accepted are very, very narrow, very strong. But this curative petition is also in the news because of Union of India versus Union Carbide case 2023, where, if you're not aware, I'll tell you very briefly, Bhopal gas tragedy of 1984. For that, the Supreme Court had ordered compensation for the victims. Central government, Union of India, filed a curative petition asking the Supreme Court that you please enhance this compensation to be paid to the victims of the Bhopal gas tragedy. But this curative petition was dismissed by the Supreme Court in 2023. Because here the court said, if there is gross miscarriage of justice, we will accept your curative petition. If there was a fraud or facts were suppressed while hearing this case, then we can accept a curative petition, otherwise no. That is why the grounds are so difficult to achieve that majority of these curative petitions are dismissed. Let's look at some more facts. This curative petition must be accompanied by a certification from the senior advocate, highlighting substantial grounds for its consideration. So senior advocate has to certify that this curative petition should be heard. Why? Because gross miscarriage of injustice has taken place. Why? Because principles of natural justice have been violated. So certification of a senior advocate is must. Can be important for your exam. Then first, it has to be circulated to a bench of the 3 senior most judges of the Supreme Court, along with the judges who passed the original judgment, if they are available. If they are dead, if they have resigned, if they are retired, then you don't have to bring them. But as much as possible, if available, those judges who gave this judgment, original judgment, along with 3 senior judges of the Supreme Court, together they will have to hear this curative petition. And only if majority of these judges, they deem it necessary for a hearing, only then can it be considered. And then this curative petition will be sent to the same judges, same bench that had passed the initial judgment. These are the facts related to curative petition, can be important for your exam. Why? Because curative petition has been in the news over the past 2 years because of Metro Rail Corporation case, because of the Union Carbide case, because of the invocation of Article 142. That is why this topic becomes important. Let's look at another topic. Topic number 5, National E-Governance Services Delivery Assessment. E-governance is a very important tool. Birth certificate, death certificate, as much as possible should be given electronically through e-governance system. In the year 2019, this assessment was constituted. By whom? By the Department of Administrative Reforms and Public Grievances, which is a department under the Ministry of Personnel, Public Grievances and Pensions. And this assessment is conducted every 2 years. These facts are very important. This assessment is conducted every 2 years to see whether the states, we have listed down some mandatory e-governance services that mandatorily these services, whether it is birth certificate, death certificate, or any other certificate, or any other service, driving license, these services should be given through e-governance platforms, through a unified portal. This should be given to the citizens so that there is more transparency, so that there is less corruption. And every 2 years, this assessment will be carried out to see whether the states are providing these services through e-governance platforms or not. This was constituted for the first time in 2019. Every 2 years, this assessment will be taking place. And the last time it was carried out was in 2023. Although the survey results were published in 2024, in January 2024. That is called Annual National E-Governance Services Delivery Assessment. And this report, the knowledge partner of this report was NASSCOM and PricewaterhouseCoopers, PwC. Facts can be important for your exam. But under this survey, which was carried out in 2023, the Union Territory of Jammu and Kashmir tops the list of states and UTs with maximum number of 1,117 e-services. So these are the number of e-services provided by the UT government in Jammu and Kashmir. Saturation level of 76%. I told you that Department of Administrative Reforms and Public Grievances, it has listed that these are the mandatory e-services that you have to provide to the people. Out of these, what is the percentage of the services provided by the states? In 2021, it used to be 69% of these services were provided. Now it has reached up to 76%. Now 76% of these mandatory e-services are provided to the people by the states. And who is topping that list? Jammu and Kashmir. Apart from that, Assam is also doing well. Assam, Odisha, these are the 2 other states which are also doing well in terms of their ranking in the National E-Governance Services Delivery Assessment. Okay. Have you heard of this topic before? Okay. Now, topic number 6, Corruption Perceptions Index. Few facts and we will be done with this topic. This is released by whom? By the Transparency International, which is a non-governmental, not-for-profit organization. So maybe a question can be asked, Corruption Perceptions Index is released by which of the following organizations? World Bank, United Nations, Niti Aayog, or the Transparency International. It is released by Transparency International. And what this organization does, it ranks 180 countries and territories throughout the world in terms of the perception or perceived levels of public sector corruption. Public sector corruption, that means corruption by the bureaucrats, by the officials, by the politicians. What is the common people's vision or perception of corruption in these public sector undertakings or in the public sector? That is how the Transparency International, it ranks 180 countries around the world. Denmark is at the top. Finland is at the top. And what is the ranking of India? India ranks 93 out of 180 countries in this index, which was released in 2023. Maybe a statement can also be asked that India has been consistently improving its ranking in the corruption index, which is not the case because in 2022, our ranking was 85, which means we have slipped from 85 to 93 in this corruption perceptions index. Okay? Okay. Let's look at topic number 7. And there is the question on your screen. Let me know what is the right answer. Right against adverse effects of climate change is a fundamental right under Article 14 and 21, fundamental right under Article 21, a legal right, a constitutional right. What is the right answer? There's a clash between A and B. This was a case related to where a retired government officer, Ranjit Singh, filed a petition before the court asking the court that you please issue guidelines so that we can save, preserve the great Indian bustard, and the lesser floricans. And these are critically endangered species. We'll not get too deep, we'll not go too deep into this topic, but long story short, this petition was filed. The petitioner basically was asking the court to interfere so that the transmission lines, the electric transmission lines, they are not constructed in the habitat of great Indian bustard and the lesser florican, because these great Indian bustards, they come in touch with these electric transmission lines and then they die. Because these are critically endangered, we need to save their habitat. Right or wrong? Initially, orders were given by the court, and then 3 ministries, Ministry of Power, Ministry of New and Renewable Energy, another ministry, Ministry of Environment, Forest and Climate Change. These 3 ministries interfered and intervened before the court. And the court said the previous order that we had issued is not workable. It won't work. But although this case was related to issuing guidelines for the protection of the great Indian bustard and lesser floricans, but in this case, the Supreme Court gave another right to the people for the first time, where explicitly the court is saying right against adverse effects of climate change is a fundamental right, both under Article 14 as well as Article 21 of the Constitution. So not only under Article 21, but under Article 14 as well as Article 21. And how did the court come to this conclusion? Maybe that is where our interesting discussion will come up. Supreme Court said, look at Article 48 capital A and Article 51 capital A. One deals with directive principles of the state policy. The other deals with fundamental duties. One directive principle is the state shall endeavor to protect and improve environment and to safeguard forest and wildlife of the country. This was not originally part of the Constitution. It was added to the Constitution by the 42nd Constitutional Amendment Act. Not just this, fundamental duties chapter also got added to the Constitution through 42nd Constitutional Amendment Act based on the recommendations of the Swaran Singh Committee. So basically the court said, if we have Article 48 capital A, if we have Article 51 capital A, that means our Constitution believes that we have to take care of the wildlife and conserve the environment. Climate change is affecting them as well. Climate change is affecting people as well, which means it is violating Article 14 as well as Article 21. Right to life and right equal protection of the laws. But you might say, sir, why this question can be asked? Look at the question which was asked in Prelims 2017. Which principle among the following was added to the directive principles of the state policy by the 42nd Amendment to the Constitution? And the answer is B, participation of workers in the management of the industries. So maybe sometimes themes are repeated by the UPSC in your prelims. Maybe the UPSC will ask which of the following directive principle was added to the Constitution to the directive principles by 42nd Amendment. And here also the answer is Article 48 capital A. Why? Because this is what we call backward linkages. You have to link it by looking at PYQs, by looking at current affairs. May not even be asked in the exam, but may be asked in the exam. That's how you prepare. So you don't only prepare what will be asked in the exam, you prepare a lot more with the hope that from whatever you have prepared, questions would be asked. Right? That's why this becomes important. And Supreme Court said Article 21 recognizes right to life and personal liberty, where Article 14 indicates that all persons have equality before law and equal protection of the laws. Supreme Court said these are the two articles which are the sources of the right to clean environment as well as right against adverse effects of climate change. This is also a fundamental right, but keep in mind both under Article 21 as well as Article 14 of the Constitution. Okay, very good. Let's look at topic number 8, Project 39 capital A. Last 1.5 years, 2 years, death penalty has been in the news quite a lot. And I don't have to explain why. Leave that aside. Death penalty was in the news. For that, there is National Law University in Delhi, which has a project called Project 39 capital A. And what is this Project 39 capital A? It has been inspired by Article 39A of the Constitution, which is a directive principles of the state policy. DPSP this year becomes very important. Article 39B and Article 39C, which we will discuss in our subsequent classes. 39B, it would say, material resource of a community shall be so distributed so as to subserve the common good. Now, what is this material resource? Can private property also be viewed as a material resource of a community? For that, we had a doctrine given by Justice Krishna Iyer, wherein he had said that even the private property is a material resource of a community and as such can be distributed under Article 39, Clause B of the Constitution. But this doctrine was overturned by the Supreme Court recently, where Supreme Court said not all private property is the material resource of a community. So DPSPs are in the news. There has been a lot of debate on the death penalty. Project 39A was in the news. And you need to know few facts related to it, that it is the initiative of the National Law University in Delhi. Project 39A, what is its objective? It's not only talking about death penalty. It is talking about a lot of legal conversations around legal aid, torture, mental health of people in prisons. So it is this Project 39A which is focusing on these various aspects of our law. And for that, let's look at the question. According to Article 39 capital A, the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall, in particular, provide free legal aid. Free legal aid is mentioned where? Article 39 capital A of the Constitution, which is a directive principle. But this was not originally part of the Constitution. This was added to the Constitution again by the 42nd Constitutional Amendment Act. And Project 39A of the National Law University in Delhi is inspired from this article. So both these statements are correct. Let's not forget there is also a debate on the emergency. a Bollywood movie is about to be released, starring Kangana Ranaut, Honorable MP from Mandi, from Himachal Pradesh in Lok Sabha. And during emergency, 42nd Constitutional Amendment Act was passed. So 42nd Constitutional Amendment Act 1976 can be important for your upcoming prelims exam. Clear? Let's look at topic number 9, split in a political party. And this is not just related to Shiv Sena, this is related to the NCP as well. NCP also got split. Now there is a question on your screen and I will give you 1 minute to answer this question. Which of the following statements is or are correct? When there are 2 or more claims to a recognized political party, the Election Commission has to necessarily recognize one faction as that political party. The Election Commission of India rules on a split in a political party only if it is a recognized political party. Third, the Election Commission of India cannot freeze the name or the symbol of a political party under any circumstance. Select the correct option from below. I said I'll give you 1 minute, so don't jump the gun. Read the question carefully. Here is a recognized political party. Now, what is a recognized political party? A political party may either be recognized by the Election Commission of India, recognized as the national political party or the state political party, or a political party may be just registered with the Election Commission of India. If there is a split in a registered political party, Election Commission of India tells them, either you solve your problems internally or you go to the court, don't come to us. But if it's a split in a recognized political party, Election Commission of India gets to decide which of these factions, 2 or more factions, is that recognized political party. So that recognized political party can be given its symbol, can be given its name, because name and symbol, these are the 2 important assets of a political party. That's how people vote for them. But according to the rules, if there are 2 or more factions of a political party and all these factions are claiming that we are the real political party. For example, there is Ajit Pawar faction, there is Sharad Pawar faction, there is Uddhav Thackeray faction, there is Eknath Shinde faction. Election Commission of India gets to decide which is that real Shiv Sena or NCP. And how will Election Commission of India decide? Election Commission of India will decide by looking at the strength of that faction in the organization and the strength of that faction in the legislative wing. Because not all members of that political party will be there in the legislature as MPs or MLAs or MLCs. There are office bearers as well. So Election Commission of India will look at the constitution of that political party and basis that constitution, what that constitution talks about the office bearers, who are the office bearers, and then decide whose faction has the majority, which faction has the majority in the legislative wing, in the organization wing, and that's how Election Commission of India will decide. But if Election Commission of India is unable to decide, it may say that none of these factions are the real political party, are that recognized political party. So the statement 1 which says when there are 2 or more claims to a recognized political party, the Election Commission of India has to necessarily recognize one faction as that political party. No, it may not recognize any faction and say, no, this symbol has been frozen now, this name has been frozen now, you can take another symbol, you can take another name. So statement 1 is incorrect. Election Commission of India rules on a split in a political party only if it is a recognized political party. Yes. For registered political parties, Election Commission of India says resolve on your own internally or go to the court. The Election Commission of India cannot freeze the name or the symbol of the political party under any circumstance. No, it can. If none of these factions are able to prove that they are the real political party, or sometimes before Election Commission of India gets to decide which is the real faction, which is the real political party, before that it can also freeze the name and the symbol of that political party. So that is why A, only one statement is correct. Right or wrong? Great. Because according to the Symbols Order of 1968, read this paragraph carefully. When the commission is satisfied that there are rival sections or groups of a recognized political party, and all of them are claiming that we are the real political party, then what Election Commission of India will do? It will ascertain all the facts of this case. It will hear representatives and then decide that one such rival faction or a group or none of such rival sections or groups is that recognized political party. That is the Symbols Order of 1968. And this applies to disputes in the recognized national and state political parties. For splits in registered but unrecognized parties, the Election Commission of India usually advises the warring factions to resolve their differences internally or to approach the court. Okay, let's look at topic number 10, nominated MPs of the Rajya Sabha. Ms. Sudha Murthy was nominated, a well-known social activist, a writer, was the chairperson of the Infosys Foundation as well. She was nominated to the Rajya Sabha. Now, you know, Rajya Sabha has 12 MPs nominated from the fields of art, literature, science, social service. There used to be 2 nominated members where in Lok Sabha as well, or 1 nominated MLA to Legislative Assembly as well, and these were from Anglo-Indian community. Can you tell me how this Anglo-Indian community reservation was done away with? Was Constitution amended for that? Yes. Through 104th Constitutional Amendment Act, this Anglo-Indian community reservation was done away with. That means it was not extended further, because originally the reservation for Anglo-Indians, the reservation for SCs and STs in Lok Sabha Legislative Assembly was meant for 10 years. But it keeps on getting extended by 10 years again. But in 2020, when this reservation was set to expire, Constitution was amended, 104th Constitutional Amendment Act, which further extended the reservation for SCs and STs for another 10 years. That means till 2030. But this reservation for Anglo-Indians was not extended, which means now we don't have Anglo-Indian reservation. The only nominated category in Parliament now is the 12 MPs who are nominated to Rajya Sabha by the President of India from the fields of art, literature, science, and social service. Clear? Let's look at the question. Rukmani Devi Arundale was the first woman nominated member of the Rajya Sabha. A vacancy in the nominated seat shall be filled within 6 months. Under the allocation of Business Rules 1961, the subject nominations to the Rajya Sabha is allocated to the Ministry of Home Affairs, which is the administrative ministry for initiating the process of nominations. At the center, no nominated member has yet been included in the Council of Ministers. What is the right answer? Rukmani Devi Arundale was the first woman nominated member of the Rajya Sabha. This is correct. In 1952. A vacancy in the nominated seat shall be filled within 6 months. Not necessarily, because according to 2024 data, there are still 2 seats which are left unfilled. Under the allocation of business rule, the subject nominations to Rajya Sabha, which is that ministry which initiates the process of filling these nominations? That is the Home Ministry. So statement 3 is correct. At the center, no nominated member has yet been included in the Council of Ministries. So only 3. C is the right answer. Right? Great. Let's look at another question. Which of the following statements regarding a nominated MP of Rajya Sabha is or are correct? Let me know what is the right answer in the comment section. Nominated members enjoy all powers, privileges and immunities available to an elected member of the parliament. They are not entitled to vote in the election of the President of India. In the election of the Vice President of India, they have a right to vote. If a nominated member joins a political party within 6 months, he shall not be disqualified under the 10th schedule. A nominated member is exempted from filing his assets and liabilities under the Representation of the People's Act 1951. Which of these statements is or are correct? I said first woman nominated member of the Rajya Sabha was Rukmani Devi Arundale. Nominated members enjoy all powers, privileges and immunities that are available to an elected member. Yes, they are the members of the parliament. They are not entitled to vote in the election of the President of India. Yes, they are not part of the Electoral College for the election of the President. In the election of the Vice President, they have the right to vote. Yes, because what is the Electoral College for the Vice President's election? Members of both Houses of the Parliament, which includes nominated as well as elected. If a nominated member joins a political party within 6 months, I told you when we discussed topic number 1, nominated members is given 6 months to decide if you want to join a political party. And normally these nominated members, they side with the government when it comes to the legislative business. A nominated member is exempted from filing his assets and liabilities under the Representation of the People Act. This is also correct, because you have to file your assets and liabilities if you are an elected member of the parliament. Within 6 months of your election, you have to file your assets and liabilities. But that is not a provision for the nominated members. So all the statements are correct. D is the right answer. Okay. Now let's look at topic number 11, bail in PMLA cases. Now there are some cases where you are presumed guilty unless you can prove that you are innocent. PMLA is one such case. Can you tell me which are these other cases? There are certain laws where the burden of proof shifts to the accused, meaning they are presumed guilty unless they can prove their innocence. Such laws include which of the following? Which are these laws? If you are arrested under these laws, the courts will assume that you are guilty. It is for you to prove that you are innocent, which means the burden of proof is on the accused. Otherwise, normally in the criminal justice system, the burden of proof is on the prosecution. You are innocent until proven otherwise. But this golden rule of criminal justice system is turned upside down when it comes to certain laws. And which are these laws? Yes, under NDPS Act, Narcotic Drugs and Psychotropic Substances Act, you are presumed guilty. You have to prove that you are innocent. Same PMLA, same UAPA, same under the Atrocities Act. So D, all of the above is the right answer. We will not go too deep into these PMLA cases. We will just understand one thing, bail. Because these laws have been in the news for a long time. Mr. Kejriwal was arrested. A lot of his ministers were arrested under PMLA. And what is that? Section 45 of the PMLA? Twin test. hear the prosecution. If I am arrested under PMLA, now I will apply for bail, right? While hearing my bail application, it is necessary for the court to hear the prosecution. If the prosecution says, okay, release me on bail, the court may release me. If the prosecution says, no, we object to the bail, even then the court can grant me a bail, but subject to this twin test. And what is this twin test? If the court believes that you are not guilty, or if the judge is satisfied that the accused won't commit another offense, that means if I have been arrested under PMLA, I can apply for bail, but for that the court has to necessarily hear the prosecution. If the prosecution objects, even then the court may grant me bail, but under two strict conditions. First, the court will have to be satisfied that I am not guilty. That means even at the bail stage, the trial may not have begun. At the bail stage itself, the court has to be satisfied that I am innocent. And if I am released on bail, I will not commit any other offense. Only if these twin tests are satisfied, only then I can be granted bail in the PMLA cases. But Mr. Kejriwal, he was released on an interim bail just before the Lok Sabha elections. Not regular bail, interim bail. Why? Because the court said Mr. Kejriwal is the convener of a national political party. Mr. Kejriwal does not have any criminal past. We are in the midst of a very important 2024 Lok Sabha election. So we will release this person on an interim bail so that you can campaign in the Lok Sabha elections. After that, you come back to the prison. Similarly, bail was granted to Ms. K. Kavita because even this twin test can be weakened for somebody who is a woman or elderly, sick, and somebody who is less than 16 years of age. That means if you are a woman, you can be released on bail even if you don't satisfy the twin test. That's how K. Kavita was granted bail. If you are elderly or sick, or if you are less than 16 years of age, even without satisfying the twin test, you can be granted bail. That's all that you need to know regarding the bail in the PMLA cases. Skip everything else because that won't be relevant for the prelims examination. Similar, there is UAPA of 1967, Unlawful Activities Prevention Act. Why was this in the news? Because the online news portal, NewsClick, the founder editor of this NewsClick portal was arrested under UAPA. Why? Because there were a lot of allegations against him that you are discrediting the government's efforts in the fight against COVID, that you're taking funding from the Chinese, so on and so forth, many allegations, and he was arrested under UAPA. But what you need to know from this case is that when this NewsClick founder editor was arrested, he was not informed of the grounds in writing. Supreme Court then said this arrest is illegal. Why illegal? Because you have to inform the person you are arresting And you have to inform the grounds on the basis of which this person has been arrested. That too in writing, in written form. It can't be oral. Oral communication or oral communication or over a WhatsApp call, you can't announce the grounds on which you have been arrested. On the basis of which you have been arrested, the grounds have to be mentioned in the writing. That's all that you need to know regarding this case. Forget about the rest. Let's look at topic number 13, the Bharat Ratna case. And what was this case about? Mr. Advani was given Bharat Ratna. And when Mr. Advani was given Bharat Ratna and the president conferred Bharat Ratna on Mr. Advani, because he was sick, he could not visit the Rashtrapati Bhavan to accept this award. And that is how president went to his home to confer Bharat Ratna. And there Prime Minister was also present. Some people allege that Prime Minister has disrespected the president. Why? Because Prime Minister was seated when Bharat Ratna was conferred on L.K. Advani. Only the president was standing. Is that correct? Incorrect? What are the rules? Rules say president and the recipient both should be standing, while all other guests, including vice president and prime minister, are to be seated. But if the recipient is sick, indisposed, you may be seated. So Mr. Advani was seated, Prime Minister was seated, only the President was standing. Was it violation of any rule? No. Why? Because this is what the rule is. This Bharat Ratna, which was constituted or initiated in 1954, it is not part of Padma Awards. Because Padma Awards are Padma Vibhushan, Padma Bhushan, Padma Shri. The highest civilian award given to somebody for exceptional service in any field whatsoever. That person is conferred Bharat Ratna by the President of India. And you can be a citizen, you can be a foreigner as well. And we have seen foreigners also have been conferred with Bharat Ratna. For example, Nelson Mandela, Khan Abdul Ghaffar Khan were conferred with Bharat Ratna. These facts can be important. And the Bharat Ratna is recommended by the Prime Minister to the President. No committee is set up to look into who is best suitable to get this Bharat Ratna. No, the Prime Minister recommends to the President. It's binding on the President to confer Bharat Ratna on that individual. But once Bharat Ratna was announced, but was then revoked. It was not conferred. Can you tell me which was that case? Anybody? Related to Subhash Chandra Bose. It was announced once, but then it was not conferred. This was the only instance where the award was announced but not conferred because the family and others objected because they dispute the death of Netaji Subhash Chandra Bose. But these Bharat Ratna awards were suspended twice. One in 1977 to 1980, when Janata Party was in power, and then between 1992 onwards, because during this period, multiple public interest litigations were filed, saying that Bharat Ratna and Padma Awards, these are titles within the meaning of Article 18 and as such are unconstitutional. It is only after the court ruled that these Bharat Ratna or Padma Awards, these are not titles within the meaning of Article 18. That's how Bharat Ratna can be conferred now. And it is not necessary to confer Bharat Ratna every year. It depends upon the discretion of the President acting on the advice of the Prime Minister. In fact, once there was a question asked on Bharat Ratna in your prelims examination. So now again, if Bharat Ratna was in the news, this can be important for your exam. That is how we have to link current affairs with the PYQs. These Bharat Ratna awardees, what is their status in the warrant of precedence? I don't have to explain what warrant of precedence is. For example, there's a government function. What will be the seating arrangement? Broadly. In warrant of precedence, the first is the president, then the vice president, then the prime minister, and then just below the cabinet ministers and the chief ministers, we have the holders of the Bharat Ratna. So Bharat Ratna holders in the warrant of precedence, they are below the cabinet ministers, but they are above the judges of the Supreme Court. They are above the chief election commissioner. They are above the deputy chairman or the deputy chief ministers of the states. That can also be asked in the examination, because on warrant of precedence also, question has been asked previously in the prelims exam. Right? Great. Let's look at topic number 14, Sita Soren case. And what was this case all about? JMM bribery case or judgment. It was overturned. Because in JMM bribery case in 1998, the Supreme Court had said bribe is allowed inside the parliament if you are taking bribe to vote in the parliament or to speak in the parliament. Bribery is allowed. But that judgment was overturned, where the Supreme Court said that bribery cannot be viewed as something which should be allowed for a member of the parliament, because privilege which is available to the members of the parliament are such, only those things can be considered as part of the privilege of the legislators, which help the legislators in discharging their duties as a legislator. But you can't say bribery is also involved. Bribery is also required for a legislator to discharge his duties. No, that's not the case. So Sita Soren case is related to the privileges, immunities of the legislators. Quick revision. Let's look at the last topic, 15, topic number 15, electoral bonds case. And in this electoral bonds case, in ADR, the petitioner was Association for Democratic Reforms. The Supreme Court said electoral bond scheme is unconstitutional. Why? Because it violates Article 19(1)(a), which is the right of the citizens to know, to make an informed choice. As well as it violates Article 14, because the Supreme Court said that this electoral bond scheme is manifestly arbitrary. Manifestly arbitrary in the sense, because prior to electoral bond scheme, only those companies which are making profit, which have generated profit in the last 3 years, 7.5% of that profit they can donate to a political party. Now, what the change was, that even if you are a loss-making company, you could also donate to a political party. The court said this is manifestly arbitrary. How can you allow even the loss-making companies to donate to a political party? Because if that is the case, there is always a quid pro quo, give and take. So electoral bond scheme was declared unconstitutional by the court in this ADR case because it violates the citizens' right to know. It also violates Article 14 on the grounds that it was manifestly arbitrary. That's what you needed to understand. These were 15 topics that we had picked today to cover a large portion of the current affairs from January to May. Tomorrow, we will have another 15 to 20 quick topic discussions on the important current affairs. Now, whatever questions you have, please let me know. I'll be happy to answer. And if this session was of some benefit for you, please let me know in the comment section as well. Does judiciary come under the definition of the state under Article 12 and 36 of the Constitution? Article 12 talks about the definition of the state, which means if this state is violating your fundamental rights, you can drag the state to the court. Now, constitution makers thought that there is this conundrum that can we say that a body, an institution which is capable of protecting your fundamental rights is capable of violating your fundamental rights as well? Because we go to the court in case our fundamental rights are violated. How can we even imagine that an institution we approach for the protection of the fundamental rights is capable of violating fundamental rights as well? That is why Article 12 does not explicitly talk about judiciary as a state under Article 12. But Supreme Court has an administrative side as well. Administrative side comes under Article 12, but not the judicial side. In 42nd Constitutional Amendment Act expanded the scope of Article 31C to include all DPSPs. Is the scope of 31C still there? 25th Constitutional Amendment Act 1971. What it did? It added Article 31 capital C to the Constitution. And Article 31 capital C, what it says? It says if Parliament wants to enact a law, what sort of law? To give effect to Articles 39B and 39C, two directive principles. Even if this law violates Article 14, 19 and 31, merely on this ground, the law cannot be declared unconstitutional. That means what this 25th Amendment did, it gave primacy, superiority to two directive principles, 39B and 39C, over three fundamental rights, 14, 19 and 31. When the emergency was imposed, then Constitution was amended again, 42nd Constitutional Amendment Act. Previously, two directive principles were given superiority, primacy over three fundamental rights. Now, because of this 42nd Amendment, Parliament said to give effect to one or all DPSPs. That means now all DPSPs were given primacy over Articles 14, 19 and 31. This was challenged in the court in a case known as Minerva Mills, where Supreme Court said judicial review is part of the basic structure. Supreme Court also said harmonious relationship between DPSP and fundamental rights is also part of the basic structure. So this 42nd Amendment is unconstitutional, which means then we have to go back to the previous interpretation. And what is the previous interpretation? That only two DPSPs have superiority over three fundamental rights, 14, 19, 31. But then 31 was also repealed in 1978. So which means now the status is two DPSPs have superiority over two fundamental rights, 14 and 19. Now we will say, sir, 19 also was removed. That was 19(1)(f). Right to property was removed as a fundamental right. The remaining 19 is still there. So that means on other aspects of Article 19 and Article 14, 39B and C will have superiority over. Doctrine of eclipse, for example, there is a provision of a law, and now comes a judgment saying this provision is unconstitutional. Now, after some time, if there is another judgment which says no, this provision is not unconstitutional, this provision will revive back. That means it does not mean that this provision gets deleted. It is only eclipsed by this judgment. And once, because of the later judgment, if this eclipse has been removed, that means this provision comes back to life. Doctrine of eclipse. This is one simplistic meaning. Otherwise, there is a lot more. Is it possible to add those contents that you have explained in the PDF? Yes, this PPT, along with the annotations, whatever I've written on this PDF, will be available in my Telegram channel. You can join that channel and I will make it available. Sir, don't you think that in electoral bond, if 19(1)(a) will be allowed, then vote it violate right to secrecy of an individual, which comes under Article 21? That is something which court also grappled with, this question. What should prevail? The right of the entire population to know who is funding whom, and the right of one individual to keep his donation secret from the people. Whenever there is a clash between group rights and individual rights, it is the group right which will prevail. So it is the right to know of the electorate which will have privacy over the right to privacy of an individual. If you have already followed any monthly current affairs magazine, please continue following it, revise it, underline it multiple times, and then supplement it with Conquer Prelims 2025. How to revise polity for prelims exam? Don't miss these classes. That's how you'll be able to revise. High courts have the power of judicial review. But nominated members can't vote for president election. How? Equal powers. We didn't say equal powers. What we said is that nominated members enjoy all powers, privileges, immunities available to elected members of the parliament. In the sense, you can speak in the parliament. You can vote on bills. You can be a member of a parliamentary committee. Those privileges which are available, you cannot be arrested without the permission of the speaker. Or if you have been arrested, the speaker should be informed. Those privileges, immunities which are available to elected member are available to you as well. January 18th, Bangalore. Yes, we have an offline workshop at our Rajaji Nagar Centre. If you are in Bangalore and should you wish to come, you can. Sir, according to Article 20, Clause 2, no person shall be punished for the same offence. If I committed a crime and prosecuted upon me, and if I again commit, then what will happen? Then you will be arrested again. It does not mean that you commit murder, which is an offence, and for that you have served your time in the jail, and then once you are released, you will again commit the murder, saying no person shall be convicted for the same offence more than once. When you commit another murder, that is another offence. Then you commit another murder, that's another offence. New conduct of election rules 1961, lack of transparency. We will discuss that. Tomorrow we'll discuss a lot of these issues. And since it has appeared in the current affairs of the past month, that is why we will cover it in the stage 4, where we will cover current affairs of June to April 2025. There is no entry fee. A bill introduced by a private member, somebody who is not a minister, is a private member bill. And there have been 14 instances where private members' bill has been passed in the parliament. 9 times these bills have originated in the Lok Sabha. 5 times these bills have originated in the Rajya Sabha. So private members' bills have also been passed in the parliament. And what's a private member resolution? A resolution introduced by a non-minister is a private member's resolution. If it is voted upon, that resolution is not binding on the government, because only a statutory resolution is binding. And please understand here, when I'm taking these lectures, I'm assuming that you have completed the syllabus. That is why I'm assuming that you know a lot of facts and concepts already. And we are here just to revise, not to teach afresh. Okay, then that is it for today. Lecture number 1 of stage 1 of Conquer Prelims 2025. Lecture number 2 related to Indian polity tomorrow. And today and tomorrow we will discuss all the important current affairs topics which were in the news between January to May. And please understand, there are various current affairs topics which were in news between January to May, but I won't cover them here. Why? Because those topics were also in the news later. So those we will cover in the stage 4 of Conquer Prelims. Why nominate only the elected members, only those who are elected by the people? Their assets and liabilities are to be explained, to be mentioned, to be shared with the Election Commission, because that is for the transparency of the voters. But since nominated members, they don't contest elections, there is no need for that. Can nominated members be included in the Council of Ministers? Yes. Okay, thank you so much for staying with me. This was lecture number 1. Tomorrow, let's meet again at 7 o'clock for lecture number 2. Till then, have a great time. Revise. Stay safe. All the best. Don't panic. You have everything that is required to crack this exam. See you tomorrow. Bye-bye. Good night.